Welcome to the Legacy Leaders Podcast. Are you doing the best for your client to help them create their legacy? Are you creating a plan that goes far beyond finances to help people ensure that it becomes the driving force behind all decisions? On this podcast, hosts Katie Beth Hand and Stan Miller will help you with growing your practice and your clients' peace of mind. Together, they bring the best and brightest minds to share with you how to help your clients develop their best legacy. And now, here are your hosts, Katie Beth and Stan.
Okay, so welcome to Legacy Leaders Podcast. I'm your guest host, Carol Eddy in Denver, Colorado, and I'm excited to introduce to you our guest today, Roseann Murray. Hi, Roseann, and welcome.
Hi, Carol. Thank you for having me.
So happy to have you. So can you tell our listeners just a little bit about your background and how you got into estate planning?
Sure. So I'm a little different than most people that went to law school. I started doing medical transcriptionist when I was about 20, and I was making good money, so I kind of pigeonholed myself. And so at about 35, I was sore from all the repetitive use and bored to tears. And I just thought, I guess I'll go to law school. So I did. And my favorite teacher in my favorite class was estate planning, trust. They call it trusts and estates in law school. And I'm also not, I'm not a litigator type. So it just kind of fit me, I think.
Mm-hmm. And then once you got out of school, how did you start your practice? How did that come about?
My original position, I actually lived in Thornton at the time, was with a gentleman here in Longmont, doing estate planning and, probate and all that stuff, elder law. And I worked with him for about 3 years, because quite honestly, when you go to law school, they don't teach you how to practice law. They teach you the law. So I needed guidance. I needed to learn. And I stayed there for about 3 years. And I've been on my own since 2011.
Nice.
Yeah, it's been a while.
Yeah. So can you tell me what are some of the common issues you help clients deal with in your practice?
Sure. So being an estate planner, of course, I do wills and trusts. But within that, all families are different. So typically, not always, sometimes people have, a child with disabilities or something, and that comes up right away. But in a lot of families, as we all know, families have issues. And I'll ask them, okay, is there anybody we need to be worried about? And the original answer is usually no. And it's like, well, there is the one thing. So because while you're doing estate planning, you want to make sure everybody that's going to get the money is covered and protected. So if you have somebody with disabilities, you have to do a special needs trust, which you can do within the will or in a trust, to make sure they don't get kicked off benefits by getting an inheritance unless it's several million, and it won't matter. And then we also do things to protect kids. Sometimes kids just don't know how to handle money. So we can stick it in a spendthrift trust and have the trustee dole it out. That can happen with just in general, not good with money. A lot of times I do that with somebody that might have a drug problem. And that's, I think, to the beneficiaries looks like punishment, but it's a protection for them. So, and then of course we deal with, kids and when will they get their money and
all the age stuff. And whether or not parents want to control that, all that kind of stuff.
Right, exactly. I look at it as protection. I just know if I would have gotten an inheritance in, like, say, in my 20s, I just would have bought a really fancy car. And, your priorities change.
Yeah.
And especially when you're younger, maybe you get a few $100,000, and that's real money for sure, but it's not going to last you the rest of your life.
But as a 20-year-old, you would think, oh, that's everything. I can go play.
Right. They'll look at 300,000 just for an example, and to them it'll look like 20 million.
Yeah.
And
yeah, it definitely changes as you get older.
Definitely.
curious too, when you do set up these spendthrift trusts, or even just a general estate planning, what do you recommend for as the trustee? Because a lot of times I find that the families end up being the trustee of the estate, and sometimes it's okay, and sometimes it's overwhelming. So how do you help them navigate whether or not somebody in the family should do it, or whether they should hire someone to be a trustee for this, to basically administer either a trust or do this probate, or after that's the executor. Basically, if they're in the executor role, it's even more common.
Right. So it depends on the type of trust. With spendthrift or with special needs trust, it's very defined on what they can provide for that person. And usually that person is dependent a lot of times on their parent. So in that case, I think it's well, if their parent's gone, on a family member. Spendthrift trusts, where you just have a trustee saying, yes, you can have money for this, or no, you can't have money for that. As well as trust for kids, depending on when they're going to get their money. I normally don't recommend a family member because of the emotional parts to it, and it would put a strain on their relationship. And I've seen that happen, and it's, when you go to a family member and say, can I have, and the family member says no, that creates quite the conflict.
Right. So who do you have take on that role if it's not a family? How do you recommend someone to be a trustee other than the family?
I always talk to them about maybe family friends, but there's also professional fiduciaries that do that specifically.
Okay.
And then the emotion is taken out of it.
Yeah. Yeah, I think that's really important. And then on the second part of that question, on the executor, do you recommend that a family would do that or not?
Usually they want a family member, which is normally fine, but I've certainly seen families, and that's break apart, and then, and then you can still have that emotional part of whoever's the executor being pressured or being questioned. So my practice is to, discuss, let's say they have 5 kids. I'll say, okay, how well do they all get along? And of course, the more personalities, the more children, the more likely there is that somebody's going to have a problem with at least one other person, in which case I don't recommend that the child does it. It puts too much strain and pressure on them, and just creates family conflict, which can happen anyway, but that's more likely. So yeah, really depends on the number of kids. A lot of people have 1 child or 2 children, and they get along great, not a problem. But yeah, everybody is different.
Absolutely. I totally understand that. So what do you think the biggest challenges that your clients face?
Family issues.
Yeah.
And
basically things we're just talking about. Where are the conflicts going to happen? Sounds like.
Exactly. And that, especially when you have a larger family, that really concerns them. And there are issues that, if you have a potential beneficiary child that maybe you're not going to leave money to because they're estranged, we do our best to try to document things very carefully, as far as capacity goes. Like if they're a little older, and we, depending on the money, I might just say, let's just have a doctor put a note in that you do have capacity to sign a will. And testamentary capacity is actually less than contract capacity, but just for a little stopgap there that hopefully would send a family member that's upset would go into maybe a lawyer's office, and then they would be explained, well, you're going to have to find a doctor to prove incapacity. You're going to have to not use this doctor. It's just an uphill battle, and it's very expensive. Now, if you're dealing with multi-million-dollar estates, then you have to go a lot further than that.
Yeah, that makes sense.
Mm-hmm.
So can you tell us about a story about things going wrong for a client that came to you?
Sure. So, a lot of times things happen over title issues. So right now I'm actually in the process of doing a probate administration for a family that the mother and the father own the house jointly. At some point, they refinanced, and the refinance people put them as tenants in common.
Oh,
So that's the only reason we have to do probate. And although probate's easy in Colorado, they should have never been put in that position. It would have just been a question. I don't know what happened. Maybe they just didn't ask, or they didn't understand. So now we have to open probate to clear that up. Another issue I've had, this was bad. So I have a gentleman, and he had put his son on, he has multiple rental properties, not coerced into it. But he put his son on as a joint tenant of each and every property, thinking that, quote unquote, he would take care of the rest of the family. And in the interim, the son became estranged, and of course would not sign the property back to the dad. But since there was no coercion, our only option was to break up that joint tenancy, where when he would have died, the son would have gotten the full property, and put it in tenants in common, so the son just owed it 50%. So yeah, things happen. I've also had situations where, people, unless you know this stuff, you probably don't necessarily know that beneficiary designations go first. No matter what the will says, the will can say that person is disinherited, and for the purposes of this will, considered to have predeceased me. If you have that person on as a beneficiary on an account, it doesn't matter. It goes directly to that person. So I did have a family, and mom, whatever Wells Fargo was decades ago, opened her checking and savings account, listed her kids as equal beneficiary, son and daughter. They didn't like each other. And then she did a handwritten will that said, my daughter is to get the house and my son is to get the money, because they were about equal. Well, because of the beneficiary designation, the daughter got the house plus half the money. So we deal with some entitlement issues, and it's really sad, but it happens.
No, just really reinforces why you should have an attorney on your team instead of just putting it together, because you might miss something.
Right. So in general, I think, so I'm a true believer in, I don't know how to be a plumber, so I'm not going to try to be a plumber. It's just better to go to the professionals in whatever it is, if it's plumbing, if it's an attorney, if it's a financial planner, because I think in the long run, you can create more problems and more headache and a lot more money than if you just would have gone to get some help. So
well, and I think there's a misconception out there that people think an estate attorney, you only need that if you're rich, and there's a lot of little things that you would miss if you don't use an attorney to draft these, and it doesn't have to be exorbitantly expensive if it's a simple estate.
No, it doesn't. When I set my fees, I'm pretty reasonable. I think I'm my hourly rate is reasonable, and I will look at that situation. If I have a very simple will, I know it's not going to take me 5 hours to create this thing.
Yeah.
And so I will bill accordingly, because just like any other professional, we don't start from scratch every time.
Yeah. Yeah. That would make our jobs impossible.
Impossible. Exactly. Exactly. Or if you just have a couple that come in and say, well, let's say all we want is for it to go to son and daughter, they get along. And then if my son or my daughter dies, I want it to go to their kids. Well, that's what the intestate statute says. So, and I'll tell them that will happen with or without a will. And that does happen, but there's a lot of occasions when it won't. And, that could be for different reasons. Maybe you don't want it, or you say it goes to the kids, but if the kids are gone, oh, gosh forbid, I don't want it to go to my sister, Carol, because we don't get along. Well, you got to look at the statute that's created to say who gets what if there isn't planning done. So it literally can be sometimes, it's your hard-earned money. You can do whatever you want with it.
Yeah, I'm not sure the kids always see that.
No.
They think it's their money before they have it.
Exactly.
So tell me about a case that went really right and they were just so thankful to have you help them.
A lot of times, well, back in the day when taxes were complicated and we did all those fancy trusts, we could literally save people hundreds of thousands of dollars. But now, since the estate tax for a couple, as you well know, is like 12.7 or 8 per person, and it's going to sunset, or it's supposed to sunset next year, but still 5 million. And you don't have the issues you used to have. So basically, it's just finding people that they just don't know what to do, and could be the issues with the family. It could be they're worried about their children or a disabled child. And I know all the ins and outs and all that, so I can ensure for them that their child will not lose benefits, and explain to them even the disability process for Social Security disability, and stuff like that. And also people that start off, they do probate, and you can do it on your own, and it's explained, but it's frustrating. So I find a lot of people that I can really, really help is just walk them through that, and just kind of, be an ear to listen to without nickel-diming them every single cent. So I guess that's generalities, but in general.
Yeah, that's okay. No, it just helps. What about in terms of, you also do elder law and Medicaid. Are you seeing more cases of people's parents not having enough coverage for long-term care and having to utilize Medicaid?
Yes, definitely. Because as you know, it's so expensive to get somebody in to an assisted living or memory care that assets can be dwindled very quickly. So yeah, that happens a lot, and people are still surprised that Medicare won't pay for it.
Yes.
And that they'll have to put up all their, drain their assets. There's ways around that. As I would go to you for that, because I know there are some financial tools you can do for a community spouse or the spouse that stays at home. But along those lines too, is I have people come in they're trying to prepare for Medicaid, to get on Medicaid. So they want to do an irrevocable trust where they give all their assets to the irrevocable trust, and lose control over them, which they don't usually understand that at first. And then I usually talk them out of it, because if you have decent assets, I always say to them, why would you want to be in a Medicaid bed?
Mhm.
And of course, the perfect answer to all that is to have set up long-term care prior to the need.
So
But
do you have people trained? Because for the listeners, just know that often if you try to set all those things up, there's a 5-year look back rule. So if something happens and you have to wait 5 years before it actually works, do you find there are options for people that come in last minute? They're going into a home and there's a spouse. Is there anything they can do to help protect their assets? What they can, because the reality is Medicaid is going to go after those assets in order to pay for care. And I worry most about the spouse that didn't know that it affects them. And yes, you can keep your house, I think, in a car. And I think what's the threshold of assets? I think it's 110.
110, 120 for the minimum. And then you can go up depending on how many assets you have to the maximum, which I think is 185. I'd have to look at the exact numbers. But so, and then we can do the whole Medicaid planning, making sure that we can get all the expenses covered with the stay-at-home or community spouse. And that is actually a question I have for you, Carol. I always just refer it out, but aren't there some annuities you can do to up the stay-at-home?
Well, it's tricky because whether they do them in advance or if they try to do it last minute, because if they're going to do it last minute, then you're taking that snapshot. I did just hear about an annuity that might be an option if you need it right now, but it gets a little confusing and it's really case by case, which it really is a combination of me working with an estate attorney. So I would do the financial side, the estate attorney kind of on the elder law does the legal side to make sure all the ducks are in a row to make sure we
right
correctly, because they do come. So eventually
right.
Medicaid wants to collect. And
for our government, as long as they take to do things and as long there's problems, but they are very, very good at finding assets.
Yes.
I don't mean to criticize, but it's a fact. And people, that's what they always want to do too when they're looking at the 5-year look back, is like, oh, I'm just going to give my child, even just the yearly $17,000. You can't do that because it's a presumption on Medicaid's part that any gift you give was done just in order to get qualified for Medicaid. And then the presumption can be overcome, but it's not easy.
Yeah, exactly.
And then there are exceptions. If you have a child living in the house for 2 years before, you don't have, they won't go after the house for estate recovery. But that's even really questioned anymore. They used to just go through, yep, here you go, I can prove I lived there. They needed services, okay, but now you got to jump through a lot more hoops to even get that exemption. So yeah, it's sad. I mean, it used to be easier. There used to be a 3-year look back. And then I mean, different states were different, but I think Colorado went to 5, like in the late 2000s.
Yeah.
So that's a long stretch of time when you don't really think about that ahead of time.
Right.
It's their health's failing. What do we do?
Well, and like you said, I think the biggest misconception out there is that Medicare does not cover it. They're like, oh, well, no, I have Medicare. Like, well, that doesn't cover long-term care costs. No. That's a whole different category, and really getting that information out to the public, to me, is very important so they can plan ahead.
Correct. Yeah. It just makes sense. It's healthcare, right? So Medicare should cover it. But, so it's a surprise.
Yeah. So is there anything else we didn't talk about that you'd like our listeners to know?
I'm sure. So I did kind of want to talk a little bit about misconceptions. So a lot of people think that trusts are magical and they want to put all their stuff in a trust so that nobody can ever sue them. We can put everything in the trust, but they can still sue you if you have control over those assets. So then you're talking about, for it to become magical, it has to be irrevocable, meaning you can never change it. You cannot be your own trustee. You can be your own beneficiary, but it's up to the trustee if they're going to give you any money, or what the gentleman I worked for a while used to say, then you rely on the kindness of strangers to give you money. So unfortunately, I mean, yeah, you can do a lot for your kids with spendthrift trusts and keep creditors away from them. But, you know, if you're afraid, what if somebody slips and falls on my property? You know, that type of thing. Another thing I do want to cover is people get really nervous when they hear the word probate. And so I'll start with probate in Colorado is the easiest state. It does it's all informal here. It's not what you hear about like in New York, California, Florida, where it took years and the attorneys took a bunch of the money. That does not happen here. Other states, the attorneys get a percentage of the estate, and you have to slow walk everything before a judge. Everything here is informal. That being said, I always do what I can to make sure my clients don't eventually have to go to probate, whether that's a trust or a beneficiary deed for, you know, beneficiary designations. Because honestly, if you don't have to do it, who would want to? But so what happens is somebody's told by a friend or a neighbor, and they say, well, you don't want to go to probate. And the way you prevent that is put your son on the house with you as a joint tenant. That way the house doesn't have to go through probate. Well, what happens there is you make a gift to that son. And let's say you have 5 kids. The son never has to share with the other kids because they own that in joint title. So let's say you put your son on that, and your house is worth $500,000. That's your son's tax basis. He doesn't live there. You die, and your house is worth $1 million. You have just created an unnecessary $500,000 capital gain.
Yep.
That, I mean, that's it. And so you know, just don't do that. And then alternatively, what if your son got in an accident and got sued? Now your house is up for grabs. Or if, like what happened to my one client who put his son on those properties, you become estranged later in life. So that's my big, please don't ever do that. It's just, it can create so many more problems than it solves. But this again is when they don't want to, they're like, I don't want to go in to an attorney and spend thousands of dollars to get this done. It doesn't cost that much, you know, depending on if it's super complicated with, you know, $1 billion, then maybe, but
Yeah.
it's just, and we could do trust to prevent probate. I always recommend trust if you have like a house here and a house in Florida. You don't want to do probate in both places, especially not in Florida. But
yeah, because their rules are much different than ours. So we're in a very friendly state.
we are, Colorado is said to be quote unquote the easiest place to die. So that's,
At least we did something right.
we did something right. There's not a lot of work for us probate lawyers, but yeah, like I said, there's different ways you can prevent probate, and I always aim to do that, and not necessarily with the trust, because trusts tend to be way more complicated and more expensive. So there's other avenues out there that you can explore and do and prevent it all the same.
Yep.
Without putting your child on the house, by the way.
Yeah, absolutely. So as we're wrapping up, how can our listeners get in contact with you if they would like to work with you?
Well, my main office is in Longmont. I have a satellite office in Denver. So I have offices both places. People that live in Longmont don't want to drive to Denver and vice versa. And I'm usually in Denver about once a week, no given day. But you can reach me on the best phone to call me on is 720 272-7605. In Longmont, my office is located one block east of Hoover off 18th. And my Denver office is across from City Park in I guess you'd call it Uptown Denver. Or you can look my website up. It's the Murray Law Firm LLC.com.
Well, thank you so much for doing this interview. I really appreciate it. For all our listeners, this is the Legacy Leaders Podcast with Carol Eddy. And our guest today has been Roseann Murray. For more information about Roseann and the work that she does, please visit murraylawllc.com. And Roseann, thanks again.
Thanks, Carol. I appreciate it.
You've been listening to the Legacy Leaders Podcast with Katie Beth Hand and Stan Miller. For more information on them and the show, please visit pinnaclelegacylaw.com. If you like what you've learned today, do share the program with your friends and subscribe wherever podcasts are found.